Hola a todo el mundo y bienvenido a mi canal. Yo me llamo Sirene. Soy abogada afro-latina, licenciada y practicante de leyes criminales, pero como todos ustedes, a mí me fascina cuando estamos hablando de casos de crímenes reales. En este video vamos a seguir hablando del caso de Lori Vallow Daybell. Si quieren más video en español, nada más dime allá abajo. Hi everyone and welcome back to my channel. My name is Desiree. I'm a licensed and practicing Afro-Latina criminal attorney who, much like the rest of you, has this severe fascination with true crime cases. Listen, the last two videos we were continuing on in our saga of Lori Vallow Daybell. We were talking about her background, who she is, what she was, what she's alleged to have done, her crimes, trickery, treachery, and deceit. In this video, we're going to continue on in the third part of our saga. But before we do that, I'll give you a little brief recap of where we left off. In our last video, we talked about how Lori was tried in Idaho for the crimes against her for the murders of her children, Tylee and JJ, as well as conspiracy to commit the murder of her fifth husband's only wife, Tammy Daybell. Lori was ultimately convicted of all charges, and a few months after the conviction, 5 months to be precise, she was extradited back to Arizona. So what exactly did she do in Arizona? If you'll remember, on July 11th of 2019, her enforcer, her brother Alexander Cox, shot and killed her fourth husband, Charles Vallow, inside of her Arizona home. At the time, law enforcement cleared all parties and said that Alex acted in self-defense. Since then, law enforcement took a deeper look into Charles' murder and determined, yeah, no, we were wrong. So now, Lori is facing charges for conspiracy to commit the murder of Charles. In addition to that, do you remember what I said about Brandon Boudreaux? On October 2nd of 2019, someone driving Charles Vallow's vehicle tried to shoot and kill Brandon Boudreaux. Brandon is Lori's niece Melanie's ex-husband. The timing of everything was just far, far too suspicious. Prosecutors and officers and law enforcement and everyone involved believe that the person that was driving Charles's car and who shot at Brandon was none other than Lori's enforcer. So now Lori is back in Arizona for 2 more trials. So your question to me might be, Desiree, why on earth are they doing 2 separate trials? Why? Lori's the defendant in both of them. So explain to me why they need to have 2 separate trials. And I will. So I just think trying both of these cases in one sole trial is far too confusing. There are 2 separate sets of facts. Charles was killed by Lori's brother, and Brandon was shot at by Lori's brother. There's 2 separate dates of incidents. Charles was killed on July 11th, 2019, while Brandon was shot at on October 2nd of 2019. 2 different locations. Charles was killed in Lori's home in Arizona, and Brandon was shot at, I believe, in the driveway of his home. It's just far, far too confusing. And I've spent the last 3 videos talking to you about this woman because there's just so much to unpack. Imagine putting these 2 cases in one trial in front of a jury and expecting them to catch up and understand everything that's going on when they're completely separate. I think the prosecution did this right. I don't feel like this was a joinder situation. And I do believe that trying her separately for both incidents is legal, appropriate, necessary, proper. Insert word here. Lori's trial for conspiracy to commit the murder of her fourth husband, Charles Vallow, is going to proceed first. But prior to that trial proceeding, and on December 6th of 2024, Lori asked the court if she could proceed pro se. Pro se is the legal term that merely means that someone is opting to represent themselves, meaning they don't want an attorney. They themselves want to be their own representation during the trial. and the court granted Lori's request.
Good morning, Your Honor. Pamela Hicks and Robert Abernathy on behalf of Lori Vallow Daybell, who's present and in custody.
Ma'am, can you tell me your name and date of birth, please?
Lori Daybell, 6/26/1973.
All right, thank you. We're here for a status conference. You've been found competent by two separate healthcare providers. Is it your intention, ma'am, you had expressed earlier that you would like to represent yourself?
Yes, sir.
Is that still your intention?
Yes, Your Honor.
All right.
Interestingly enough, the court's decision came after a Rule 11 hearing. A Rule 11 hearing is merely a hearing that happens to determine whether or not someone's fit to stand trial. Doctors at the hearing stated that Lori was fit to stand trial, and she decided she'd rather represent herself. Contrary to popular belief, defense attorneys are not the only ones who have the ability to raise competence. If anyone, any party to a proceeding, has any sort of doubts about the defendant's ability to be fit to stand trial or their competence, any party can raise it. That includes the prosecution, and that does include the court, aka the judge. I'm not really sure who raised it here, but it wouldn't be surprising to me to learn that Lori's defense attorneys raised it merely because she was evaluated for competency in Idaho before in her prior trial. So let's talk a little bit more about pro se trials. Pro se trials are interesting. And I've done pro se trials throughout my career. What I will say to you is that each jurisdiction does handle pro se trials differently. And let me explain. In some jurisdictions, the court will just give the defendant the advisement and inform the defendant, like, you're on your own. You wanted to represent yourself. You're expected to be held to the same standard as a lawyer who is trained, who knows all of this stuff, who is trained in the rules of evidence, and you're just going to do it by yourself. But more commonly, and in most jurisdictions, the court will appoint what's called advisory counsel for a pro se defendant. Advisory counsel merely is an attorney or multiple attorneys who sit at counsel table with the defendant and advise the defendant about some rules that they may be confused about. The difference between having advisory counsel and having defense counsel is that the defense attorney does all the talking for you. When you have advisory counsel, the advisory counsel can advise you. They can give you different tips and clues and tricks and anything they want to give you. But you ultimately get up and represent yourself. Here, Lori was given two advisory attorneys. I know we're all dying to get into what happened at the trial where she represented herself, but I do want to talk a little bit more about the pretrial conference that occurred before we get to the trial. A pretrial conference merely is a conference where both sides to a proceeding tell the court whether or not they're ready to proceed to trial, as well as address any pretrial motions. This might sound redundant, but a pretrial motion merely is a motion filed by either side that's asking the court to determine something. Let's talk about what specifically happened at Lori's pretrial conference, though. One of the things that happened at Lori's pretrial conference was the court deciding whether the jurors could be questioned about what they know exactly about Lori's case. The prosecution rightfully and ethically brought up the fact that Lori's national news. So we need to inquire of these jurors what they've heard about Lori, what their opinions are of her, and whether they can still be fair and impartial if they were selected to sit on this jury. Understanding that we all have preconceived notions about this woman, she is still entitled to a fair and impartial jury. What also happened at Lori's pretrial conference was that she asked the prosecution to disclose some sort of video. The prosecutor informed Lori and the court that she looked and couldn't find the existence of this video anywhere. And Lori's response to that was rather entertaining.
All right, let's deal with a couple things. First, I've received the notice of compliance. That was when the defendant requested the Gilbert video. Does that apply to the second case or this case?
Your Honor, it's an incident that occurred in January. It's not really, it was disclosed because it is mentioned in the DR. The defense had filed a motion for the state to disclose that And then had brought up again on the 11th that the state had not disclosed it, that there was some YouTube video of that. I have looked for said YouTube video. I have gone through the police report. I don't know what video she's discussing, but we're not aware of any video that hasn't been disclosed. So I'm just providing notice that disclosure is complete as to that police report that is peripherally relevant.
All right. Any comment on that?
Yes, Your Honor. For clarity, is the state proposing that there is no video or that they don't have to give it to me because it's not attached to that DR number?
I think what she said was she's not aware of what video you referenced. So as far as her knowledge, she doesn't have it and doesn't know about it.
So I should go directly to Gilbert Police Department to get it?
Well, last time you were in court, you said your investigator or someone told you about it.
A mitigator
A mitigator.
showed it to me.
If they have that link, why don't they just send it to the state, and that may help the state determine if that's something they've already disclosed?
I will tell you why they won't, because that is my former team and they will not do anything to help my investigator, my paralegal. They won't give us any information that they found. They won't talk to us at all because apparently there was a conflict. So they will not help us. They will not send us anything. They will not email us anything. They will not answer anything that we ask them to. So that has been the response from my former defense team. That's where we are.
And the final thing that I want to discuss that happened at Lori's pretrial conference was the fact that the court questioned her about her late endorsement of witnesses. Again, contrary to popular belief, the prosecution is not the only side in a criminal case that has to abide by disclosure deadlines or the rules of discovery. As we all know, defense is not required to do absolutely anything, but should they choose to do something, they're still bound by the same rules as the prosecution. So Lori endorsed her witnesses late, and the prosecutor in this case moved to strike the late endorsement. The court informed Lori that it agreed with the prosecution because the prosecution does have an opportunity to speak to all the witnesses that she endorses. And if she does so late, the prosecution is not afforded that same opportunity. The court gave Lori the option to proceed without any of her late endorsed witnesses or to continue the trial. Her response to the court was quite fiery.
Your Honor, my understanding is that the state has interviewed every single person on my witness list previously. That's where I got the people from the interviews that they had from the state previously. So I understand that they're allowed to do another interview of them, but they have interviews of every single person that is on my list, with the exception of one,
Which is who?
which is Nate Eaton.
Okay.
And
When you say the state's done the interview, do you mean police or someone from the prosecutor's office?
In discovery, I have interviews with police on every single one of the witnesses that are on my list.
Okay.
So I know that they had their addresses. I know that we were trying to get the addresses to them in the quickest way possible. And where I am at the jail, the communication is very difficult for me to get a hold of my investigator, to get a hold of my paralegal. I'm 23 hours a day locked down. If I don't have Wi-Fi, I don't have a phone. If I don't have battery, I don't have a phone. I don't have access to get to people. So I understand the time constraints, and we're doing the best that we can of getting things answered, getting things put together.
Lori ultimately decides that she's not going to continue the case and she wants to proceed pro se. Some of you may be asking yourselves, Desiree, please explain to me why on earth this woman would decide to proceed pro se on such severe charges. I'm going to pose a question right back at you. What does she have to lose? Lori was already tried and convicted for 3 separate murders in Rexburg, Idaho. Lori was already sentenced to 3 consecutive life sentences in Rexburg, Idaho. So best case scenario, she's found not guilty, and she's still serving the rest of her life in prison. Worst case scenario, she's found guilty, and she's still serving the rest of her life in prison. She has absolutely nothing to lose by proceeding this way. And just to clarify, when I'm talking about best and worst case scenario, I'm talking about from her perspective. She has nothing to lose. The decision kind of made sense for her. The first day of Lori's trial began on April 7th of 2025. On this day, Prosecutor Trina Kay delivered her opening statement on behalf of the student.
So I'm going to need you to stay close to me the next couple days. Mel, too. She can't go to Utah. They're planking some kind of intervention, but want Mel out of the way, so I'm left alone. I need to come get the stuff at your house tomorrow and secure it. Lots to do. Thanks for standing by me. It's all coming to a head this week. I will be like Nephi, I am told, and so will you. Lori Daybell, the woman seated over here, wrote this to her brother Alex Cox on July 9th of 2019, 2 days before they killed Charles Vallow. But to understand why this is so meaningful, why this is relevant, you have to understand the context. So let's talk about it. In July of 2019, Lori Vallow was married to Charles Vallow. Lori Vallow lived here in Arizona, Chandler. Charles Vallow lived in Texas. In July of 2019, Lori Daybell was Lori Vallow, married to Charles Vallow. In July of 2019, Lori Vallow wanted to be Lori Daybell, wife of Chad Daybell. And in July of 2019, Lori Vallow wanted to keep the same lifestyle that she had with Charles. And she could get all of this if Charles was dead. She could marry Chad Daybell and become Lori Daybell. She would get a $1 million life insurance policy from Charles Vallow. She would get Social Security for herself and their son, JJ, as a child of a dead spouse. And all of this would be true if Charles Vallow was dead. So what about Nephi? Well, Lori Vallow, Chad Daybell, and Alex Cox all believed that those who disagreed with them were dark, possessed by evil spirits, sometimes called Z's or zombies. Sometimes they had names for these evil spirits like Ned. Lori, Chad, and Alex used religion, the Church of Jesus Christ of Latter-day Saints, and a story of Nephi, a prophet, who was directed by the Holy Spirit to kill Laban, to obtain brass plates and secure the long-term prosperity of Nephi's descendants. Lori used this religion and the story of Nephi as justification to kill Charles Vallow, just like Nephi killed Laban. On July 9th of 2019, Lori Vallow invoked Nephi when she messaged Alex to provide them with that religious authority to kill Charles. After months of trying to get rid of him, they were finally ready to be like Nephi.
Also on this day, Lori delivered her opening statement on behalf of herself.
And the evidence will show that Charles showed up at our Chandler residence around 7:30 in the rental car I booked for him on the morning of Thursday, July 11th, 2019. The evidence will show that Charles began texting with my brother, Adam Cox, before he entered our residence, and that Charles and Adam were discussing in their text communications that my other brother, Alex Cox, was at the residence. The evidence will show that on the morning of July 11th, that Tylee was asleep in her room and my brother Alex was asleep in the guest room. The evidence will show that when Charles entered the house, only JJ and I were awake and present. The evidence will show that after we put JJ in the rental car, that Charles came back into the residence to receive his phone, leaving JJ in the front seat of the rental car with the engine running. He was 7 years old. The evidence will show that Charles began to scream at me when I refused to hand him his phone. The evidence will show that Charles' screaming woke up Tylee and Alex. The evidence will show that Tylee came out of her room with a bat to protect me, her mother,
from her stepfather, Charles Vallow. The evidence will show that Tylee and Charles fought over the bat, and that after a struggle over the bat, Tylee fell onto the ground, and Charles lifted up the bat to hit Tylee with the bat. The evidence will show that Alex then intervened to protect Tylee from being hit with the bat. He did not have a gun. He was not wearing a shirt. He was pulling up his jeans because he just woke up and came into the room where he heard the screaming. The evidence will show that Alex and Charles got into a physical struggle for the bat and fell onto the ground. The evidence will show that Tylee, who was on the ground, was lifted up by me and sent outside to get away from the struggle and to protect JJ, who was still in the running car, in the rental car in the driveway. The evidence will show that after this struggle on the ground between Charles and Alex, that Charles prevailed with the bat and began to come towards me with the bat as I ran away from him into the kitchen. The evidence will show that at some point while I was running away from Charles, who was chasing me with the bat, that Alex apparently retrieved his gun. The evidence will show that I ran outside to the children and that Alex shot Charles in self-defense. The evidence will show that Tylee and I had both run outside without shoes. The evidence will show that JJ was still in the front seat of the rental car with the engine running and struggling to get out of the car. Tylee was trying to keep him in. The evidence will show that Tylee and I got into the rental car with JJ and drove away. The evidence will show you that I drove the children away from the residence towards JJ's school. Can I grab a tissue?
Yes.
I have seen a lot of channels discuss their opinions on her opening statement. Some of those channels were even ran by other attorneys. I think most people ripped Lori apart for her opening statement, but I'm going to respectfully disagree. Lori is a vile woman. I think most people would consider her a monster. What she did was absolutely abhorrent. She is just terrible. But compare her to a lot of the attorneys we've seen on this channel. Compare her opening statements to some of the opening statements from trained and licensed attorneys that we have seen on this channel. Lori didn't do that bad. She had a theme. The evidence will show. She even got emotional in her opening statement. Whether or not I believe those tears is another thing. But she showed the jury some emotion. On top of that, I think she spoke with conviction. She sounded confident in what she's saying. It's probably because she believes her own lies, but whatever. I think she presented a relatively strong opening statement, especially for someone representing themselves. The second day of trial continued on April 8th of 2025. On this day, prosecutors called law enforcement officials that responded to Lori's phone the day of Charles's shooting. The third day of trial continued on April 9th of 2025. On this day, the prosecution called more law enforcement witnesses and Lori had an opportunity to cross-examine all of them. Unlike her opening statement, what I will tell you is that her cross-examination skills were trashy.
So is your opinion then an educated guess about what really happened?
It's based on known facts.
Okay. Were you aware, Detective, that my husband and my brother were very good friends?
No, ma'am, I didn't know the relationship.
Did you know that they hung out and played golf together?
Objection, relevance.
Sustained.
Your Honor, I'm going somewhere with this.
Well, I guess.
My follow-up question will explain.
I guess you can answer if you knew that they played golf.
I did not know.
In all of your investigation of my life, you never came across this information?
Objection relevance.
Sustained.
Are you familiar with my husband's wishes for his funeral?
Objection relevance.
Sustained.
Did you learn in your investigation that he named my brother Alex as one of his 5 best friends?
And I'm going to object again to relevance.
Sustained.
Also on this day, the prosecution called a woman by the name of Nancy Jo Hancock, who testified that she went on a date with Charles after Charles learned about Lori's affair with Chad.
Nancy Jo, right?
Correct.
And we have not met before,
We have
correct?
not?
Okay. And you stated that your husband, or my husband, told you that he was going through a divorce. Is that correct?
That's correct.
And did you have any way to verify that?
No, I didn't try to verify that.
Okay. So did it surprise you later to find out that we were not in the process of a divorce?
Charles was in the process of a divorce.
He was not in the process of a divorce. Did it surprise you to find that out? You've seen it all on TV where we're not getting divorced.
Okay.
So on the website that you met him, did he say he was divorced?
I'm not certain.
Would you have gone on a date with him if he would have said he was married?
If I would have realized how married he still was, maybe not. But I just met for dinner. I wasn't sleeping with him or anything.
Do you go on dates with married men?
I'm going to
Not
object
naturally?
argumentative. I'm going to also object under 611 for harassment.
All right. I'll sustain the objection.
Your Honor, do I not have a right to cross-examine this witness for what she has already testified to?
You can cross-examine her about what she's testified to.
So you did go on a date with a married man,
I went on a date with Charles.
but you did not know he was married.
I knew his divorce was not final.
His divorce was not started.
Okay.
Okay. So in your text messages, you asked Charles if he was a good kisser. Is that correct?
Maybe, sure.
Did he answer that text message?
I'm
gonna
sure.
object to
I'm sure he did.
relevance. Again, 611 harassment.
I'll sustain the objection for relevance. And hearsay.
So are you trying to tell me and this jury that you went on one date with my husband and he told you all the details of our lives?
I'm telling you the truth, and that's what I know.
So you spent your whole date getting to know each other, talking about me.
Don't flatter yourself. No, we did not spend the whole time talking about you.
I found Lori's cross-examination of Nancy Jo to be insufferable. She was weirdly possessive over Charles in all her questions that she asked to Nancy Jo, as if she didn't allegedly, because it's still the middle of trial, order a hit out on this man. She kept making statements like, my husband, oh, so you date married men, and the like, and it's like, lady, give it up. I don't really think it was effective, nor do I think that it won her any points with the jurors. Also on this day, the prosecution called one of Lori's former friends, Christina Atwood, who testified that Lori told her that Charles had a dark spirit inside of him by the name of Ned Schneider. The fourth day of trial continued on April 10th of 2025. On this day, the prosecution called Lori's surviving brother, Adam Cox, to the stand. Following direct examination, Lori had an opportunity to cross-examine her own brother.
Mr. Cox, how long has it been since we've seen each other in person?
Don't know.
When was the last time you saw me?
I don't recall.
So has it been a year, 2 years, 3 years, 5 years, 6
Something like
years,
that.
7 years, 8 years?
Something.
Okay, so you have no idea.
Nope.
You have no idea when the last time you saw me in person.
I don't know the year or how many years it's been.
Okay, so did you see me at Colby's wedding in January 2018?
No, I was not there.
You didn't come to Colby's wedding.
No, I did not.
So did you see me sometime that year at my house
Possibly.
where Colby got married? That house,
I did see you at that house, yes.
at least one time.
Yes.
So possibly in 2018.
Yes.
And when was the last time we had any communications?
The last time I remember our communications was you and I were speaking in the kitchen when the family was over.
Okay, so you think that was that time in 2018?
I think so.
Okay. And were we eating my green chili chicken enchiladas?
Do not remember that.
You do not remember that?
Nope.
Is that what I made every time we had a family get together, which was like 10 times a year?
I don't remember that.
Okay. And when was the last time that we had a phone call or text message?
I have no idea.
Lori's cross-examination of her brother seemed forceful and purposeless. She asked him a million irrelevant questions, including one particular question that actually went pretty violent. I don't think Lori did herself any favors in the cross-examination of her brother. She came across really, really, really insane, I think. And on top of that, I felt like her brother came across really calm, cool, and collected. I thought he did really well in this stand. Following Lori's brother, the prosecution called Charles's sister, Kay Woodcock, to the stand. When given the opportunity to cross-examine Kay, you'll notice that Lori's demeanor was quite different than her demeanor when she was cross-examining her brother Adam.
Ms. Woodcock, where were you on July 11th, 2019?
At home in Lake Charles, Louisiana.
Were you aware at all of the relationship between Charles and Tylee?
It was, let's say, it was a bit contemptuous. It seemed like there was always a lot of drama going on, and so that's all I knew. He didn't say too much about it, and I didn't pry.
But you knew that there was some kind of contention going on with those two for
I
a
can't
while.
hear you.
I'm sorry. You did know that there was some kind of contention going on with those two for a while.
Yes.
Okay. And you weren't really aware of the events that happened that morning, were you?
The morning of his
July-
murder?
Of July 11th?
No, I wasn't.
Okay.
Because you didn't tell me.
Did you see or hear or personally witness me conspire with Alex Cox to kill my husband, Charles Vallow?
No, but I saw a ton of evidence that did.
Thank you. No further questions.
Comparing Lori's demeanor when she was cross-examining Kay Woodcock to her demeanor when she was cross-examining her own brother, it's like they're two different people. Lori came across as timid, shy, scared, childlike. Her whole demeanor changed when Kay took that witness stand. And I think that's because Lori knows that Kay's a spitfire. She's going to tell it like it is, and she's going to say what's on her mind. And Lori was afraid of exactly that. When she was cross-examining Kay, she asked a few questions and then sat down like a scared child being confronted by a parent. I think Kay intimidated Lori, and rightfully so. The fifth day of trial continued on April 14th of 2025. On this day, the prosecution called the medical examiner who conducted Charles's autopsy to the stand. Also on this day, the prosecution played numerous audio clips to include the clip of Lori calling Charles's life insurance company, demanding a payout. The 6th and 7th days of trial continued on April 15th and April 16th, 2025. Over these next 2 days, the prosecution called numerous law enforcement witnesses to establish the timeline of events here. But also on the 7th day, the prosecution rested its case. The 8th day of trial continued on April 17th of 2025. On this day, Lori informed the court that she wasn't going to present any evidence, nor was she going to testify. The 9th day of trial continued on April 21st of 2025. On this day, both Lori and the prosecution delivered their closing remarks.
Just 7 days after this defendant and her co-conspirator, Alex Cox, shot and killed Charles, this defendant texted her soon-to-be next husband, Chad Daybell, about Charles's life insurance policy. Her words tell us that she was involved in this killing. Her actions and her words of texting Chad Daybell tell us the motives behind this murder: Chad and money. The morning of that 18th of July, Lori Vallow texted Chad and said, quote, "I just got the letter from the insurance company saying that I am not the beneficiary. It's a spear through my heart. Who do you think he changed it to?" Later that day, after she spoke with the life insurance company, he sent Chad another text. Quote, "So I talked to the insurance company. He changed it in March. Probably it was Ned before we got rid of him." Lori Vallow's words 7 days after Charles was shot and killed tells us that we was her and Alex killing Charles. Why? For that money.
You did not see Alex's interview, but we learned that Alex was interviewed that morning by Detective Moffett, the original case agent, whom we did not hear from in this trial. The state chose not to show you those interviews
Objection, Honor.
or let you listen to the 911 call.
Right.
The jury shall disregard that last statement. Okay, the jury can only consider what was admitted into evidence.
We learned in this trial from Officer Kautheim's testimony that Alex was injured on the back of his head with a bump and, according to his testimony, a 1-inch laceration. We did not see those pictures documenting that injury as well. We learned in this trial that we did not know, the three of us, that our interviews were being recorded. We learned that Alex's phone was taken by police and put into an evidence bag, according to Detective Duncan, and that no digital copy of Alex's phone was taken by the Chandler Police Department, even though this is their normal protocol. We learned that Alex's phone was returned to him that same day with no further inquiries. We learned that after my interview and Tylee's interview that we were introduced to a victim's advocate and that gave us further instructions in another room where Tylee and I were reunited. We learned that soon after that, all three of us, Alex, Tylee, and myself, were taken in another van and dropped off back at our house. We learned that we were instructed at that time that we could not enter the house yet, that we were directed by law enforcement to take the rental car, since all three of our cars were inside the police tape. We were directed to return later in the afternoon when the scene was cleaned up. We learned in this trial that we did as directed and left the house in the rental car close to 12 p.m. We learned that we did not return to the house until contacted by Detective Inkland to return to the house so that Alex could walk the detectives through what they call a walkthrough. We learned that many detectives were present during that walkthrough with Alex. We learned that Detective Duncan was there, Detective Coons was there, Detective Moffett was there, Detective Werther was there, and an officer with a body cam was there. And yet, we were told by Detective Duncan, the case agent on this case on the stand, that because of some problem, the walkthrough was not recorded. Detective Duncan also informed us that he does not know if any of the people present wrote a report about it. We can infer from Detective Duncan's testimony and the fact that we don't have in evidence any body cam footage of the walkthrough and no reports talking about it, that there are none, even though this would be crucial evidence for you, the jury, to have.
Sustained, the jury should disregard that comment. Again, the jury can only consider evidence that was admitted into testimony. I'm sorry, testimony that was admitted into evidence or exhibits that were admitted into evidence.
The state of Arizona has the obligation to show you evidence to prove that this event was not self-defense, as stated by the only 3 witnesses. So why not show the jury all the evidence that they gathered?
Again, sustained, the jury can only consider the evidence and testimony that was admitted into evidence.
I might have alluded to this during an earlier video, but just as a general rule of thumb, I really try hard not to object to anyone's opening or closing. The reason for that is that neither opening or closing are evidence. Opening statements are what the parties feel the evidence is going to show, and closing statements are what the parties feel the evidence has shown. I don't really make it a point to object much during either. I bring that to your attention because the prosecution objected endlessly during Lori's closing statements. I just didn't feel like it was necessary. I felt like there were some statements that Lori was making that were objectionable, but I felt like the prosecution objected far too much. It's the closing. It's not evidence. Who cares? On April 22nd of 2025, after 3 hours of deliberation over the course of 2 days, the jurors delivered their verdict.
I'll ask the clerk to read and record the verdict.
In the Superior Court of the State of Arizona in and for the County of Maricopa, State of Arizona versus Lori Daybell, CR 2021-001704-001, verdict count 1. We, the jury, duly impaneled and sworn in the above entitled action, upon our oaths, do find the defendant, Lori Daybell, as to the crime of count 1, conspiracy to commit first-degree murder occurring on or about July 11, 2019, guilty. Signed, foreperson.
Okay, so Lori was found guilty. But did we expect anything different? As I already stated, Lori had absolutely nothing to lose by representing herself here. She is in the exact same position that she was in prior to the trial commencing and prior to the jurors finding her guilty. She's still in prison for life. She had absolutely nothing to lose. I don't think she did the best job of representing herself outside of her opening statements, which were terrible. But, I mean, who knows what she's going to do for this next trial? Remember, I stated that she has one more trial pending, and that's for the shooting of Brandon Boudreaux. We will cover that case on this channel, and that's specifically because we already covered the entirety of Lori's story. As always, thank you guys so much for watching. Please be sure to like, comment, share, and subscribe. Until next time, y'all take care.